Industry risk premiums, IRPs, are essential adjustments in business valuation and damages calculations, reflecting the unique risks of specific industries. In legal analysis, IRPs must be applied using transparent, data-driven methodologies, thoroughly documented, and tailored to the facts of each case to withstand judicial scrutiny. To apply industry-specific risk factors in legal analysis, legal professionals and valuation experts must incorporate industry risk premiums, IRPs, into discount rate calculations. This involves identifying the unique risks of the relevant industry, quantifying these risks using reputable data sources, and clearly documenting the rationale and methodology. Courts require that IRPs be supported by empirical evidence, consistent with professional standards, and explained in a manner accessible to judges and juries. Theoretical foundations of industry risk premiums, or IRPs. Industry risk premiums are adjustments added to the cost of equity to account for risks inherent to a specific industry that are not captured by general market risk measures. These risks may include regulatory changes, technological disruption, cyclicality, or capital intensity. The IRP is a standard component in the build-up method for estimating the cost of equity. Federal courts apply the Daubert standard, requiring expert testimony on IRPs to be based on reliable, peer-reviewed methodologies and empirical data. Experts must be qualified, use transparent methods, and provide clear documentation. The Delaware Chancery Court is more skeptical, demanding rigorous, case-specific justification and empirical support for IRPs, with detailed documentation tailored to the subject company and industry. Professional standards, ASA, HCPA, RICS, emphasize recognized data sources, transparent calculations, and reproducible assumptions, with common exclusions stemming from speculation, unsupported inputs, or circular logic. Sector-specific risk factors and IRP ranges. IRPs vary by industry, reflecting unique risks like tech disruption, regulation, or market cyclicality. For example, technology IRPs range from 1.5% to 3.0%, while emerging industries face higher uncertainty at 2.0% to 4.0%. Courts and professional standards demand IRPs be tailored to industry-specific risks, supported by empirical data, and transparently documented to ensure credibility and compliance. Calculation methodologies and data sources. The build-up method calculates the cost of equity by adding the risk-free rate, equity risk premium, size premium, industry risk premium, IRP, and company-specific premium. Key data sources include Morningstar/Ibbotson SBBI, Duff and Phelps, Kroll, and PwC valuation guides. Best practices emphasize using reputable, current sources, clearly documenting calculations and rationale, and justifying company-specific IRP adjustments with empirical evidence. This ensures accuracy, credibility, and compliance with professional standards. Best practices for legal professionals and expert testimony. Transparency is key. Document all sources, assumptions, and calculations. Use peer-reviewed, data-driven sources for IRP selection and maintain consistency across cases, explaining any deviations. Ensure defensibility by justifying IRP choices under cross-examination and communicate findings clearly in non-technical language. Subject valuations to peer review and quality control for reliability. Key finding: courts often exclude IRP testimony that is speculative, unsupported, or lacks transparency. Common pitfalls and how to avoid them. Generic or unsupported IRPs. Use reputable, current sources. Ignoring company-specific risks. Document and explain modifications to the base IRP. Lack of transparency. Provide clear, step-by-step documentation of calculations and assumptions. Subjective judgments. Justify adjustments with empirical evidence and align with industry standards. Industry risk premiums, IRPs, are key to defensible valuations in legal cases. Experts must use empirical data, document every step, and clearly explain their rationale. Courts prioritize transparency, rigor, and credible testimony.